Hey everybody, welcome to Hidden Horror. How are you guys doing today? So today I'm bringing you an update on the Ethan Crumbley case. Ethan Crumbley was a mass shooter. He did a mass shooting at his high school and he was pleading guilty. Well, he pled guilty. He was sentenced to life without the possibility of parole, and now he's wanting to appeal that life sentence with no possibility of parole. He's saying that he had ineffective counsel, and he wants a new judge to hear some mitigating factors, hear about his childhood and alcohol. It's called alcohol fetal alcohol syndrome also. So let me get his picture up. Okay, this is Ethan Crumbley. I checked to see if there was a more current picture um, of him as a offender incarcerated, and they're still using his old picture when he initially was arrested. So we're going to go over this article. It's by WGVUnews.org. It's titled Oxford Shooter Appeals Life Sentence Claims Ineffective Counsel. It's by Rick Pluta and it's dated July 11th, 2025. The Oxford High School shooter has asked the Michigan Supreme Court to order a new hearing before a judge to reduce his sentence of life with no chance of parole. The shooter's new legal team says his previous counsel failed to take crucial steps to protect his interests before the then 16-year-old pleaded guilty to multiple counts of murder, terrorism, assault, and firearm violations. Four students were killed and seven people were injured in the mass shooting. The shooter's new lawyers from the State Appellate Defense Office, SADO, argue that at a minimum, a new judge should hear expert testimony on fetal alcohol syndrome, a troubled home life, and other mitigating factors before imposing a new sentence. Through his offense, though his offense is heinous, how our courts treat even those who have committed the most heinous crimes matters deeply, said the brief arguing for the Supreme Court to hear Ethan Crumbley's case. The tragic nature of Ethan's crime cannot give courts an excuse to overlook errors that occurred in his legal proceedings. The circuit court did more than overlook these errors. It blithely and repeatedly found that nothing could or would make a difference in the sentence imposed, death in prison for someone 15 years old at the time of their offense. Sato attorney Jacqueline Overy said this appeal is not about relitigating the convictions, but requiring the court to consider mitigating factors that should have been part of the sentencing decision. Overy said that would align with court precedents that require unique considerations for younger defendants, even those charged as adults with violent offenses. They involve chronological age, which includes brain development, she said. They involve the family and home environment a child grew up in and the possibility of rehabilitation. Ethan was 15 when he committed his offense, she said. He was very much a youth at the time, but he was not doing youthful things. How about that? He was planning to kill, to harm as many people as he could, and he did that. So, no, he wasn't acting like a youth. He was acting as an adult, and that's why he was charged as an adult. Overy said the case is also relevant because there are other defendants convicted as teens or young adults in state custody who are entitled to new sentences under court rulings. It matters how we sentence those who have done even the most heinous crimes, and there are several hundred people in Michigan who, because of recent court decisions, will be resentenced for heinous crimes, she said. The Michigan Court of Appeals declined to reconsider the sentence in May, and a spokesperson for Oakland County Prosecutor Karen McDonald's office said the Supreme Court should let that be the final word. The facts are undisputed. On November 30th, 2021, the shooter murdered Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling, wounded 7 others, and terrorized an entire community, said Public Information Officer Jeff Watrick in an email to Michigan Public Radio. We are confident the Supreme Court will concur with the lower courts and uphold his sentence. The shooter's parents are serving prison terms for manslaughter convictions. They were charged with failing to act on signs their son's mental condition was deteriorating and for failing to secure the semi-automatic firearm used in the shootings. The Michigan Supreme Court refused to dismiss the charges in a 2023 decision that was the first that allowed for parents to be held criminally liable for a school shooter's actions. Now, I'm going to try to make it plain and I'm going to try to make it simple. Mr. Crumbley, in your own writings, you wrote you would go to jail for life. You are going to die in prison. Is that the best way to live? No, but you decided, you made the ultimate decision to take a gun to school, do a mass shooting where you killed 4 of your peers, 4 other high school students. Again, Justin Schilling, Tate Meir, Hannah St. Juliana, and I'm always missing the one. Madison Baldwin, you killed them, you murdered them, you gunned them down for no cause, and you should never get out. You knew it. You knew it when you did it. You knew it before you did it. And now you pled guilty. You took responsibility. You're never getting out. They never can come back. So you should not get a second chance. And you're actually lucky that the state of Michigan does not have the death penalty, because if the state of Michigan did, I believe your case was ripe for you to be sentenced to death for what you did. No, you have every day going forward to think about your actions, how you took the lives of others, how you harmed this community, how you devastated the lives of the victims' families. You hurt a lot of people. Your parents, they've been sentenced to 10 to 15 years in prison each. And we're going to forget about you. That is all. Thank you for spending this time with me. I really, really appreciate it. I want you to stay safe, stay smart, stay savvy, be well, all my friends. Bye, everybody.